Ascent Audio, a division of Recorded Books, presents Copyright, What Everyone Needs to Know, by Neil Weinstock Netanel. Narrated by Steve Menasche. Introduction. Copyright law was once an esoteric backwater, the special province of professional authors, publishers, and media companies. That's no longer the case. In our age of social media and cloud storage, we have become a copying and sharing culture. In turn, copyright law now directly implicates much of our everyday communication, work, and entertainment. In today's world, questions about copyright abound. Do we infringe copyright when we post on YouTube a video of our 2-year-old child dancing to a popular song? When we share a clip from The Daily Show on Facebook? When we email friends a copy of a newspaper article? When we pin on Pinterest a photo we found elsewhere on the web? When we store our music and movies in the cloud? When we subscribe to services that enable us to watch TV shows on any internet-connected device? These questions are highly contested. Copyright law has been unable to keep up with the explosion of new technologies for disseminating and enjoying cultural expression. Quite often the law is unsettled or unclear, and even when the law provides a clear answer, there is still the question of whether the law should remain as it is in the face of rapid technological change. Movie studios, record labels, publishers, and major authors associations regularly push Congress to amend our copyright law to give them more effective tools to quash the widespread unlicensed copying, sharing, and remixing of copyrighted works. Technology companies, consumer advocates, and many academics vigorously resist those moves. Indeed, they generally champion peeling back copyright owner rights to allow greater leeway for personal copying and user-generated content. Copyright, in short, has come to be immensely controversial. The 2012 battle over the proposed Stop Online Piracy Act, known as SOPA, provides a still pertinent example. SOPA was backed by the so-called copyright industries, movie studios, record labels, print publishers, video game producers, and other content-producing industries that view robust copy protection as central to their business. SOPA would have required that Internet search, social media, payment processing, and technology companies impede individual access to foreign websites featuring allegedly infringing material. SOPA met its defeat at the hands of a popular outcry joined by Google, Facebook, Twitter, eBay, and other social media companies. It was withdrawn from consideration in Congress after some 7,000 websites coordinated a service blackout to protest the bill's purported threat to Internet freedoms. Today, the copyright industries continue to insist that Congress must amend copyright law to target the massive online piracy that, they claim, threatens the copyright industry's economic viability. By contrast, those who led the charge against SOPA retort that the copyright industry's heavy-handed efforts to stamp out piracy would chill the freewheeling wellspring of online creativity, commentary, and information on which we have all come to rely. To navigate between the opposing, equally dim prospects of ruinous piracy and heavy-handed censorship is a complex undertaking. No less daunting, even for the educated layperson, is to understand the law and conflicting policy arguments that fuel the copyright debate. Further complicating the mix, government officials have declared that the time has come for a comprehensive revision of our copyright law. In 2013, Maria Palante, then the Register of Copyrights, famously set out her vision for what she labeled the next great Copyright Act. Since then, Congress has held no less than 20 hearings on copyright reform. Following suit, the Department of Commerce issued a white paper proposing legislation on key issues of copyright policy, creativity, and innovation in the digital economy. And the Copyright Office has issued reports proposing legislation on matters ranging from mass digitization of books to music licensing. Academic commentators and think tanks have proffered their own blueprints, often sharply disagreeing with the vision advanced by copyright industry lobbyists. This book provides answers to the questions about copyright law that are critical to following the copyright battles fought out in courthouses, administrative agencies, and the halls of Congress. I also untangle the heated debates regarding copyright raging in online forums, mass media, and academic and industry conferences. In so doing, I identify the combatants in the battles about copyright's present and future, and examine the key arguments they present. As we shall see, the battles over copyright play out within a broader market context. Social media and digital technology are rapidly upending the business models upon which traditional news and entertainment companies, and many creators, have come to depend. I explore that phenomenon and explain how it colors the debates over copyright law. Before we proceed, a law professor's disclaimer. My discussion is not meant as a comprehensive explanation of copyright law in all its complexity. Further, I focus on understanding the debates about copyright law and policy, not on what courts are likely to hold in any particular case. Nor do I address federal and state laws outside of copyright law, such as trademark and unfair competition laws, even though these laws might apply in certain circumstances. Finally, despite the global reach of online communication and copyright markets, my overriding focus is on U.S. copyright law and policy, although I do place U.S. copyright in a global context in Chapter 6 and compare U.S. copyright law with copyright laws of other countries on several occasions. In short, while this book provides a guide to understanding copyright law and the ongoing battles that surround it, this book is not intended as legal advice, and you should not rely on it for that purpose. Chapter 1. Copyright: What it is and what it is not. One cannot follow the debates over copyright's present and future without understanding copyright's key doctrines and concepts. This chapter provides that understanding. The copyright law of the United States is a product of over 200 years of judicial decisions and congressional legislation. It spans from the Copyright Act of 1790 to our current copyright statute, the Copyright Act of 1976, as amended numerous times since 1976. As copyright law has evolved, copyright's scope and duration have greatly expanded. In 1790, copyright holders had only the exclusive right to print and distribute books, maps, and navigational charts, and that right lasted for a maximum of 28 years from publication. Today, copyright holders have more rights, including, for example, the exclusive rights to adapt, translate, and publicly perform their works. Those rights, moreover, extend to a much broader range of creative expression, including computer software, movies, music, sound recordings, and photographs. And copyrights now last for the life of the author plus 70 years. Copyright law has also become increasingly complex and often counterintuitive. Lawmakers have struggled to adapt copyright law to new technologies for creating, embodying, disseminating, and consuming authors' creative works. Early sound recordings, motion pictures, broadcast, cable, satellite, home audio and video recording devices, photocopying equipment, computer programs, digital technology, and the Internet have all challenged Copyright Act provisions enacted before those technologies came into being. Consequently, much of the Copyright Act is a labyrinth of detailed compromises that have been hammered out in negotiations among stakeholder industries and then enacted into law by Congress. Portions of the Copyright Act have come to resemble the tax code in their detail and impenetrability to anyone who is not an expert. Yet other key provisions of the Copyright Act pronounce broad, open-ended, common law standards. A key example is the provision that sets out 4 non-exclusive factors to guide judges in determining whether the fair use privilege applies in a particular case. Another is the codification of the idea/expression dichotomy, the principle that copyright extends only to the form in which an author expresses her ideas, not to the ideas themselves. These provisions are simply stated, but when it comes to applying them in particular cases, they are anything but simple. Indeed, the open-ended standards can be given more precise meaning only through judges' continuing case-by-case application. As a result, central copyright principles often defy clear definition. Indeed, they may be subject to inconsistent interpretations by different courts in different cases. Even after carefully parsing the applicable judicial precedents, one is often hard-pressed to find a definitive answer to whether certain types of creations are protected by copyright, who owns the copyright in a given work, when certain uses of copyright-protected works constitute copyright infringement, or whether a given use is a fair use. This chapter navigates those minefields. Copyright Basics. What is copyright? Copyright is a set of exclusive rights that the law grants to authors of original expression. The United States Copyright Act provides that authors of original expression shall enjoy the exclusive right to 1. Copy their work, 2. Distribute copies to the public, 3. Prepare derivative works based upon their work, including translations, motion picture versions of novels, arrangements, abridgments, and the like. 4. Publicly perform their work, including live performances, broadcasts, and streaming over the Internet. And 5. Publicly display their work, including displaying artwork in public places and on websites. Copyright law also provides for some significant exceptions and limitations to those exclusive rights. I discuss exceptions and limitations momentarily. Not every use of a copyrighted work without the copyright owner's permission infringes copyright, even apart from any applicable exception or limitation. It's only a copyright infringement to use a work in a way that falls within one of the copyright owner's exclusive rights. For example, I do not infringe copyright by singing Taylor Swift's recent hit song in the shower in my home. That is a private performance, not a public one, and the copyright owner's right is to publicly perform the work. Nor do I infringe copyright by silently reading a best-selling novel at my local public library. Just reading a novel does not involve copying it or distributing copies to the public. But if I should suddenly jump up and in a booming voice read the novel out loud to startled library patrons, that would constitute a public performance. I thus would infringe the copyright in the novel unless some exception to the copyright owner's exclusive right of public performance applies. What kind of creations does copyright protect? Copyright law protects original works of authorship of any kind. These include works of literature, art, music, and choreography. They also include motion pictures, television shows, and other audiovisual works. Sound recordings, architectural works, and computer programs may enjoy copyright protection as well. Copyright law protects nonfiction as well as fiction. But entirely functional creations, such as recipes and designs of chairs, machine tools, and other utilitarian articles, are typically ineligible for copyright protection, except to the extent that they contain creative expression that goes beyond mere function, such as commentary accompanying a recipe that colorfully describes a dish and its history. Beyond those basic parameters, numerous categories of creations have spawned considerable debate about whether they qualify as copyrightable works of authorship under existing law, and about whether copyright protection should extend to them. These include the design of floral gardens, which over time may be altered by the forces of nature; fashion design, since clothes are deemed to be utilitarian articles; perfume, which is perceived by smell rather than sight or hearing; and yoga routines, which might be copyrightable choreography or a non-copyrightable method for achieving health benefits. For various reasons, movie actors' performances, restaurants' artistic display of cuisine, menu commands for operating a computer program, and golf course designs also raise questions about eligibility for copyright. So do works created by artificial intelligence computer programs endowed with machine learning capability, like a new novel in the style of a famous author generated by feeding the author's works into a computer program. No matter what type of creation it is, a work must be original to qualify for copyright protection. A work is original if it exhibits at least a modicum of creativity. The Supreme Court has held that the alphabetical white-page listings of a telephone book lack the bare minimum of creativity required for copyrightability. Most titles, slogans, basic shapes, and short phrases also lack the requisite modicum of creativity. Of course, a work that has been entirely copied from another work is not original either. Likewise, works that are created by non-human animals or that owe their shape to forces of nature are ineligible for copyright protection. In addition to the requirement of originality, an author's creation is not protected by copyright unless and until the author fixes it in a tangible medium of expression. As I formulate the wording of this sentence in my head, it is not yet protected by copyright, but the instant I type the words, causing them to be stored in the memory of my computer, they are protected, assuming the requisite originality. Fixation can be on paper, canvas, stone, a website, or any other medium from which the work can be perceived or communicated. Who owns the copyright? A work's author owns the copyright in his or her work immediately upon fixing it in a tangible medium of expression. Importantly, however, authors may transfer their copyrights in whole or in part and can divide their rights by media, time, and territory. Further, according to the Copyright Act, authors may transfer their copyrights by assignment or exclusive license. Hence, if I were to write a novel, I could divvy up and transfer my copyrights, whether by assignment or exclusive license, to various parties. For example, I could transfer the North American first publication rights to HarperCollins, the North American paperback rights to Bantam, the serialization rights to The Atlantic Monthly, the foreign distribution and translation rights to different publishers in various countries, the right to display and distribute my novel electronically to Amazon.com, the screenplay adaptation rights to Barry Levinson, the motion picture rights to Universal Studios, the television rights to CBS, the dramatic rights to Neil Simon, and the sequel rights to John Grisham. I can dream, can't I? Those parties would then each own their slice of the copyright and could enforce it against anyone, including me, who uses my novel in a way that infringes their particular right. Most authors who want to make money from their works transfer all or part of their copyrights to companies that specialize in editing, distribution, and marketing. To create an original work is one thing. To disseminate it to the public is quite another. Companies that specialize in editing and dissemination include movie and TV studios, book publishers and newspapers, record labels, music publishers, and software companies. Very often, it is those companies, collectively referred to as the copyright industries, that seek to enforce the author's copyrights and lobby for longer and broader copyright protection. Do creators who create works as part of their employment or on commission own the copyright? It depends. U.S. copyright law contains a complex doctrine called work for hire. Works that creators create within the scope of their employment, or in some instances by commission for another person, are works made for hire. For such works, the law provides that the employer or commissioning party, not the actual creator, is the work's author and first copyright owner. Most creative contributions to major studio motion pictures and television shows are works made for hire, as are computer programs created by employees of software companies. By contrast, photographs taken by freelance photographers are typically not works made for hire, even if commissioned. The Copyright Act treats commissioned works differently than works created within the scope of employment. Only commissioned works that fall within one or more of 9 categories set out in the Copyright Act can qualify as a work made for hire. A creative contribution that a studio commissions for a movie or TV show will qualify. A freelance photograph will generally not qualify unless it is commissioned for use in one of the 9 statutory categories, such as a movie or TV show. Even if a commissioned work cannot qualify as a work made for hire, the creator can still assign his or her copyright to the commissioning party. By the same token, even if a work is a work made for hire, the employer or commissioning party can assign the copyright to the creator. Joint authorship. Who owns the copyright when 2 or more people collaborate to create a work? Say a lyricist and composer work together to create a song, or 2 screenwriters work together to create a script. Who owns the copyright in the jointly created work? 2 or more people qualify as joint authors if they 1. Collaborate to create a work, 2. Share creative control, and 3. Mutually intend to merge their creative contributions as part of inseparable or interdependent parts of that work. Some courts also require that the collaborators agree to share authorship credit to qualify as joint authors. Someone who contributes to a work but does not share creative control and/or does not receive authorship credit might not qualify as a joint author. Nor would someone who contributes only uncopyrightable concepts, ideas, or inspiration for a work. Joint authors share the copyright. Each owns an equal share, even if one contributed more than the other. Each joint author may use the work or license its use to others without having to ask the permission of the other joint author. But the joint author who uses or licenses the joint work must provide the other joint author with an equal share of the revenues from that use or license. Those are default rules under the Copyright Act. The joint authors may agree to different arrangements regarding licensing third parties and sharing of the copyright if they so choose. Do I have to apply for a copyright? No, you do not have to apply for a copyright. You have copyright in your work the instant that you reduce it to some tangible form in a medium from which your work can be communicated to others for a period of more than transitory duration. As noted before, that medium might be paper, canvas, film, a CD, a smartphone, a hard drive, a website server, or any other medium from which the work may be perceived or communicated, either directly or with the aid of a machine or device. Nevertheless, you may apply to register your work with the U.S. Copyright Office if you wish. There are some advantages to doing that soon after you complete your work. If someone infringes your copyright after you have registered, you may recover attorney's fees and statutory damages, which do not require that you prove actual harm. Further, if you ever want to sue someone for infringement, you must register your work prior to filing the lawsuit, unless your work originated outside the United States and you are not a U.S. national. However, you enjoy copyright protection from the moment you have fixed your work in a tangible medium of expression. Someone who copies your unregistered work without permission infringes your copyright, absent some privilege like fair use, even though you cannot bring a copyright infringement lawsuit unless and until you register the work. Copyright lawyers often refer to a work that is protected by copyright as copyrighted, and in discussing whether a creation is eligible for copyright protection, they ask whether that creation is copyrightable. Because these terms are so commonly used, I sometimes use them in this book as well. But they can be misleading because they suggest that some action must be taken to obtain copyright protection, even beyond fixing the work in a tangible medium of expression. Is there a copyright without a copyright notice? Yes. U.S. copyright law used to require that a copyright notice be affixed to all copies of a work distributed to the public. If copies were distributed without the required notice, the work went into the public domain, with certain exceptions. But Congress abolished that requirement as of March 1, 1989, as part of the U.S. adherence to the Berne Convention for the Protection of Literary and Artistic Works, which prohibits imposing formalities like notice and registration as a condition of copyright protection. I further examine international copyright relations later. Affixing a copyright notice is thus no longer required, even if it remains standard practice for movies, books, and other works. Beware, this means that, contrary to a common misconception, the vast bulk of text, art, video, and music posted online, whether in personal web pages or commercial sites, are protected by copyright, even if not accompanied by a copyright notice. For many authors, this lack of a notice requirement for copyright protection is a blessing. It means that authors cannot inadvertently forfeit their copyright by publishing their work without a copyright notice. But it also means that massive amounts of original expression posted online are protected by copyright, even if the creator gave no thought to copyright protection when creating and posting the work. The absence of formal requirements like copyright notice and registration can also greatly increase the difficulty of determining who owns the copyright in a given work. I will return to that issue later. How long do copyrights last? Copyrights last for a very long time, often more than a century. Exactly how long a given work remains in copyright depends on a number of factors, including when and in what country the work was created, in what country the work was first published, whether the copyright was renewed, the type of work at issue, and whether the author died. Thus, determining whether a work is still protected by copyright can require considerable factual investigation. It also requires thorough knowledge of the Copyright Act's labyrinthine provisions governing copyright term. To boil down those...
Sample complete. Ready to continue?